Donald Trump submits his final reply in his motion to dismiss his January 6th case, making the argument that there is no illegal conduct in Jack Smith's indictment. The Constitution protects people under the First Amendment and makes it possible for them to say things that maybe the rest of the government disagrees with. And that's exactly what Trump did. And so we're going to go through this final motion. It's the final word from Trump's team. Remember how this goes. You make a motion to dismiss. They kind of set a hula hoop. What are the bounds? What are you arguing? And Trump has made several motions to dismiss. Several we've covered here. The motion to dismiss based on statutory construction, saying that the United States Code just doesn't provide any criminal code that Trump can be charged under. We also saw that they filed a motion to dismiss based on vindictive and selective prosecution. People like Molly Gaston, the highlighter girl in the January 6th case, seemingly already had her mind made up before she joined the special counsel's office and wanted Trump basically gone, sending letters to Bill Barr in the aftermath of the 2020 election. So a lot of bias, but today we're talking about the constitutional basis for dismissal and why under the Constitution, Trump says, I can't even be prosecuted here. This all needs to go. And this is the final word. So Trump files the motion to dismiss, Jack Smith replies, and Trump issues the response. And this is what it looks like. It's a 25-pager filed in the District of Columbia, Judge Chutkan's courtroom. And this is the final word, Trump's reply in support of the motion to dismiss based on constitutional grounds, saying that the First Amendment protects him. Trump's defense writes, all right, Judge Chutkan, this is the final word here. As you know, election advocacy, including petitions to elected officials to redress election-related grievances, complaining about elections that may not be rigged, is a fundamental and time-honored tradition in our country. We're allowed to do that. The First Amendment guarantees that the president, just like everyone else, may speak out on the subject and call Congress to action. If we can say the election is rigged and something should be done about it, can Trump? Others are just as free to disagree, and they can urge Congress to take a different course. That's how our country works, and why the Constitution prohibits the state from acting as the, quote, arbiter of truth on matters of public concern. But that's exactly what the prosecution, Jack Smith, and the deranged thugs there think and see. Rather than conceding, as it must, that election advocacy is, quote, one of the broad areas in which any attempt by the state to penalize the false speech would present a grave and unacceptable danger, instead, the prosecution seeks to install itself as America's censor. We said the election was victorious for Joe Biden. Shut your mouth. Don't even challenge it at all. Otherwise, we're going to prosecute you for that. With roving authority to criminally prosecute all who speak out against the approved narratives. Now, the prosecution, Jack Smith, Joe Biden, Merrick Garland, they have no such mandate. And accordingly, the indictment is unconstitutional on its face, and it must be dismissed. Now, even if, they argue, even if the First Amendment permitted charges on this basis, which it emphatically does not, President Trump's acquittal before the United States Senate forecloses retrial before this court, as do the Constitution's guarantees of due process and fair notice. So a lot there in that sentence. So first of all, First Amendment under the Constitution says you can challenge the election. You can say it's rigged all day long. You don't get a government conclusion on that. They get to come out and say, nope, it's 100% this is accurate. And if you challenge us, you get charged. That would be crazy because what could they do next? Well, global warming is what we say it is. Okay. Your new pandemic rules are exactly what we say they are. And if you challenge us, you get prosecuted for that. Right. And that's not what we want in this country. That's kind of insane. But that's also just part one. They also say that under the Constitution, the impeachment and removal process can only be criminally charged if you are removed by the Senate. So that is the safeguard against political prosecutions. We have the first trial in the political realm. If we agree that there's overwhelming support that a person actually is impeached, right, and convicted, then we say, okay, it's clearly not political, kick it outside of the political system, and then let the prosecution start in earnest. But that didn't happen here. Trump was acquitted in the Senate. So they say the First Amendment here bars the prosecution in its entirety. All charges in the indictment, they rest solely on allegations of core political speech and advocacy. Now, you might disagree with Trump. You might say maybe it was a bad executive decision. You might disagree with his discretionary judgment. That's fine. You're free to do that. Doesn't make it a crime. Doesn't make what he did a crime. So hand-waving the First Amendment. They say the prosecution states that President Trump had a right, like every American, to speak publicly about the election and even to claim falsely, true, that there had been outcome determinative fraud during the election and that he won. But they say, but Trump did not stop there. And so they say, okay, wait a minute. So you're saying everything he said is okay? He's allowed to do that? He's allowed to speak publicly about it and even to claim falsely that there was outcome determinative fraud? Okay. But he did not stop there. Okay. So where are we going? Thus, the prosecution then premises its entire case on the notion that Trump did more than supposedly make false claims about the election. But what is that? But what, quote, more, what is the more, did President Trump do, according to the prosecution? Let's think. He made more supposed supposedly false claims, about the outcome of election. That's what they said. He's allowed to make false claims, but he made a lot of them, all right? Dozens, they said in the indictment, of specific claims that there had been substantial fraud in certain states and that dead people voted in Georgia. Now, the prosecution says generally that Trump used those lies as instruments of his 4 criminal offenses and that he used those knowingly false statements regarding specific facts to commit the crimes charged in this indictment. It's amazing that they're going to prove that. Knowingly? You really think that Trump knew that he lost the election and that was not genuine after all we know? But the prosecution does not identify any conduct, no conduct, all speech involved in those crimes other than making, in their view, supposedly false statements about the outcome. Thus, the indictment does not allege that he used lies to commit crimes. It alleged that he told lies, and those lies are the crimes. So it's literal speech. Thus, the indictment does not charge speech in furtherance of a crime, okay? It charges speech. That's it. You're not furthering some other crime. The speech itself is the crime. Now, the reason the prosecution does not identify any non-speech or any non-advocacy conduct is because there is none. Every charge in the indictment rests on core acts of political speech and advocacy that lie at the heart of the First Amendment. And likewise, all the factual allegations in the indictment pivot on the indictment's core theory that Trump allegedly engaged in, quote, fraud and, quote, obstruction by repeatedly contending in public and to government officials that the election was tainted by fraud. So if you're allowed to say the election was rigged and fraudulent once, then it's not illegal, as they admit. It only becomes illegal if you say it a number of times. So if you say it 100 times, is that illegal? Or does it need to be 1,000 times? Does that matter if you say it 1,000 times or 1 time? That's the heckler's veto, which is nuts. So what's happening here? Now, a comprehensive review of the indictment, says Trump's defense, it reveals that every operative allegation charges Trump with engaging in acts of public speech and political advocacy about the election's outcome. The indictment first alleges that Trump made a long series of public statements about matters of enormous public concern, criticizing the administration of the 2020 election, claiming fraud and other irregularities tainted the outcome in particular states, and making claims about the scope of the vice president's constitutional authority. All speech. These public statements were posted on Twitter, and all these allegations are on the prosecution's core theory that Trump supposedly spread lies that there had been outcome determinative fraud and that he had actually won. So that's all speech. He made claims about fraud. Second, the indictment alleges that Trump made statements to DOJ officials. He said to them, fraud, irregularities, tainted the outcome of the election. Again, every allegation says that Trump supposedly falsely urged federal officials that there was significant fraud in the election. He's free to do that. He's the president. Third, the indictment alleges a series of communications to state officials claiming fraud there. Again, all these are supposedly false statements was on the basis that there was significant fraud in the administration of their election. And fourth, the indictment alleges a series of communications with Vice President Pence and similar attempts with other members of Congress and so on. And fifth, the indictment says that Trump was organizing alternate electors. And once again, the basis for organizing this was asserting that the view that the actual electors were invalid because the states had been tainted by fraud or irregularity, right? So in other words, you put up 2 slates of electors. If you determine that there is fraud, you have a backup plan, right? You have a placeholder, and that's just standard business, has been in every election. So thus, every allegation in the indictment, when they summarize them all, including all the accounts charged, center on a theory that Trump committed a fraud or an obstruction by repeatedly contending that there had been fraud in the election. But Trump's defense says nope. In short, despite acknowledging from the government's own words that every defendant has a right to speak about this, they then present these statements as the only material acts of wrongdoing. Thus, this case is not about what Trump did at all. It's about what he said. Trump's motion explained in detail that claims about fraud are protected speech. Supreme Court had unanimous consensus that the government may not criminalize supposedly false statements about philosophy, religion, history, the social sciences, the arts, other matters of public concern. It's just criminal now to have an opinion? Alito said that's perilous. You can't let the state become the arbiter of truth. Otherwise, the potential for abuse of power is simply too great. In this political arena, when disputes arise that are not easily verifiable, the threat of criminal prosecution is particularly dangerous. Our constitutional tradition stands against the idea that we need Oceana's Ministry of Truth from Orwell's 1984. But even Jack Smith and the deranged thugs over there, they don't meaningfully even dispute this point. Instead, Jack Smith and they contend that Trump made not just general assertions, but he made concrete, specific statements about specific acts of fraud, and that those render his speech criminal. Oh, so you're too specific. Your speech is too accurate. The prosecution cites no authority for this supposed so-called specificity exemption. You're too accurate. You can't talk about the facts. None exists. Claims of matters of public concern are protected. Now, the prosecution conveniently omits that phrase, but they're all protected. This idea of a specificity exception also runs afoul of Supreme Court precedent. That case says you're not allowed to do it. And the speech and this other exception also does not apply. Now, they say their attempt to distinguish these cases falls flat, but instead, the First Amendment and the problems with the government's new, novel, and unprecedented theory of criminal liability, it goes beyond the indictment, but it also goes to the underlying criminal statutes that are charged in this case. So it's not only how Jack Smith is using the law, but it's the law. If the prosecution is correct and those statutes that they think apply to Trump, if they do criminalize core political speech as charged, well, then those statutes are facially unconstitutional. So if you think that you can apply those to Trump's speech, well, then those statutes are unconstitutional, if that's accurate. Or the more reasonable interpretation is that those statutes don't apply to speech. Any statute that criminalizes core political speech is invalid, at least as applied where the criminalization of protected speech is, quote, not only real, but substantial as well, judged in relation to the statute's plainly legitimate sweep. So you can have some law that might incidentally criminalize some speech, but if it does as a primary, charge, that's patently unconstitutional is what they say. Now, as discussed above, the prosecution's interpretation of these statutes entails that they criminalize a wide range of perfectly ordinary public speech and petitioning the government, and the prosecution therefore renders its own statutes invalid by seeking to extend them to Trump's speech. So if you're saying that's how you interpret the rules have to be invalid. We've seen some points here that Alito has been dissenting, and this comes from a case where I don't think that there was a majority opinion. So there was concurring opinion, and that's why they use the phrase consensus opinion. So basically they're cobbling together from a case where there's no consensus on this, a consensus. On this issue that we're seeing right now, they're using another case to say there was a concurring opinion, there was a dissenting opinion, and from that you can glean out a consensus interpretation to the Supreme Court and what they're doing. So that's why you're seeing some of that being used here. Now, at some point, we'll see if this gets settled by the Supreme Court and we'll have a majority opinion one way or the other. But carrying on, they say, in addition to Trump and his speech being protected under the First Amendment, we also have due process problems, double jeopardy problems. You can't be prosecuted for the same crime twice. They say that the impeachment clause, the text and the history support prosecution here. Remember that Trump's people say that you have to be convicted in the Senate first. The prosecution is block quoting the clause. On their view, the phrase party convicted actually means that both the party convicted and the party acquitted. So the party convicted, they say, it means either of the things, which is weird. And it also means a party who was never impeached at all. And so, yeah, obviously, as a matter of plain meaning, their interpretation makes no sense, obviously, because they're not that bright over there. Now, obviously, an acquittal by the Senate is more likely than a Senate conviction to foreclose future prosecution. So if Trump would have been convicted in the Senate, which he was not, then he could have been prosecuted outside of the political process. Thus, if the framers had wished to clarify that impeachment and the trial in the Senate would have no impact on future prosecution regardless of the outcome, one would have expected them to state that, quote, the party impeached shall nevertheless be liable and subject to the indictment. But they didn't. They said the party convicted, because you get impeached in the House and then you go to the Senate for the trial. So the party impeached would mean that if you just got impeached in the House, that you could be subject to criminal prosecution. But convicted means no. You got to go to the Senate, and Trump was not convicted either time. So proving this point, if the framers wanted to specify that only the party convicted could be prosecuted and not the party acquitted, the actual phrasing of the clause is the most ordinary and natural way to do so. Totally agree. That seems obvious. The plain implication means you gotta be convicted in the Senate, but they're not going to try to do that. And they're going to give us some background here. Hamilton talked about it in Federalist number 68, 65, other historical interpretations of this as well. The historical sources do not undermine the consensus. They're pulling some other stuff in from the Federalist Papers in Madison and elsewhere, Representative Dana in 1798 and so on. But they say here, the impeachment clause, it's rooted in the political process, and it just makes sense from the structure. It says it makes policy arguments that they don't cite any original sources. They're drawn from OLC, Office of Legal Counsel opinions. And here, in each case, the prosecution argues as a policy matter that criminal prosecutions should be treated as independent from impeachment and Senate, because the Senate trial might not result in the acquittal of a president whose political enemies deem him guilty. So they're saying actually the judicial process is safer than the Senate process. But they say, nope, sorry. This argument flips the Constitution and its structure on its head. The impeachment judgment clause and all the related impeachment clauses provide the president with critical structural protections from attacks from his political enemies. That's why we have it. Now, the requirements of impeachment by the House and the conviction by 2/3 of the Senate ensure that he cannot be removed, and then subsequently prosecuted without widespread political consensus to get there. The fact that partisan loyalties or popular sentiment might influence the Senate's decision is a feature. It's not a bug. We want it to reach a critical mass before we cross that threshold. This is why we talk about political checks and balances, and the Supreme Court has supported that as well. James Madison reinforced this structure, Federalist 47. He said he cautioned against newfangled and artificial treasons, which have been the great engines by which violent factions and the natural offspring of free governments have wreaked their alternate malignity on each other. So don't allow all sorts of weaponized political attacks to exist in your country. Now, the Democrats have shattered that, and now we've got 234 years of precedent gone. They talk about the double jeopardy clause and why it's consistent to not have two trials, a political trial and then a criminal trial. It is being prosecuted for the same crime twice, which is what they're trying to do here. So that's the next big section. Trump and the process is invalid because the Senate needed to have convicted him in order for this to carry over to the next stage. And then lastly, the final big section, President Trump did not have fair notice that the political speech is a crime. If those statutes are in fact allowed to criminalize speech, then they're invalid. And Trump had no notice that his speech could be criminalized, which means the laws are invalid. President Trump addresses this argument about whether he had fair notice about the crimes. Now, he explains that more in a different motion, which we'll cover later this week. But he says, as argued in Trump's motion to dismiss on constitutional grounds, these fair notice problems afflict the entire indictment, and the court should dismiss this in full. And the principal reason is on page 1 of the government's brief, their own brief. They say, as they proclaim, President Trump stands alone in American history for his alleged crimes. Stands alone in American history for his alleged crimes. Yeah, nobody else ever has been charged or even knew that you could be charged. We got like 20 minutes of Democrats saying, fight like heck. We're going to get out there, get in their faces, fight, fight, fight all over the place. That admits the novelty of their criminal theories. They just made it up. And such unprecedented novelty is antithetical to the constitutional requirements of fair notice. First time ever. Now, the prosecution does not dispute that there have been many challenges to the counting of electoral votes and zero federal prosecutions or even suggestions that such challenges are criminal. You guys ever prosecuted anybody else for this before? No. That the charged conduct is the same category as those historical examples indicates that no one reasonably understood the conduct. Instead, the prosecution flips the analysis on their head. They say that the absence of prior prosecutions is not equivalent to treating this as non-criminal. But the test is not whether a court said that Trump's conduct was not criminal. The test is whether a court clearly said that it was criminal, because you need to have notice of this thing. And it's the prosecution's burden to show that. They have not done that. The most specific argument that they have is this point, but as they're going to show in another motion, it is meritless. To be clear, they say that the prosecution's discussion of the Electoral College also misses the point, and attempts to distinguish the other elections fall flat. The prosecution misses the relevance of the Electoral College contest in 2016, and they say all we need to do here is apply the facts, and it's not any sort of novel judicial construction. But that's not true. They say it provides a regular course of practice. Here, the statutes do not plainly cover the conduct alleged in the indictment, and so it cannot stand. Therefore, the indictment, says Trump's defense, should be dismissed with prejudice and not come back. Sincerely signed by Todd Blanche and John Lauro, two Trump defense attorneys, and this is the final word on this one. So this will be off to Judge Chutkan's desk for a ruling, and of course, I think that she's going to respond with a big denied, so we'll see a big denied on this one, and we'll see what Trump does as a result of that, whether he appeals this on interlocutory grounds, saying that the consequence of not dismissing this impacts the election and that this should be decided now by the Supreme Court. We need to know, does the First Amendment allow the criminalization of electoral challenges? Does the lack of notice, nobody's ever been prosecuted for this before, does that violate due process? Can you be prosecuted twice for the same crime, once in the Senate and acquitted and then charged again? Jack Smith and Joe Biden, Merrick Garland, they say yes, but Trump is saying no. We'll see what Judge Chutkan says, and then of course we will carry this into the conclusion. We're covering all the Trump trials here, DC, New York, Georgia, Florida, all of them. And so we hope you join us as we continue to cover it so that we can unpack all this madness together. We'll look forward to seeing you on the next one.